This is Ann Badmus with Badmus Associates, and welcome to our April 2024 webinar, Entrepreneurship Journeys of Unbound, Exploring Immigration Routes for Startups and Business Owners as well. So we have a full hour ahead to provide information to you about this very important topic. Again, I want to welcome all of you who are on the webinar and let you know that there is an opportunity for you to ask questions at any time. So if you have a question anytime during the presentation, be sure to use your question and answer panel. This is the section that should have a question mark bubble that if you click on that, you should be able to ask your question in writing. And that will also help us keep track of all the questions that we receive and make sure we are able to answer all of them. So there is a chat feature as well, which is just sort of a, well, it's not really the place for you to put the question and answer. It'll be harder for us to track. So please be sure to use that Q&A section of the platform in order to answer your questions, or ask your questions. We also let you know that for confidentiality purposes, please be sure to ask your questions in a general manner. This is a public forum, so we want to make sure that you do not provide any personal details that could identify you and your situation, and just to make sure you keep your confidentiality up. But before I go on, I want to be sure, as I've been talking, to make sure that you all can hear me. So if you could please, if you do hear me, any one of you could just put yes in the chat feature. Great, thank you. Thank you so much. So before we talk in detail about the subject today, I wanted to, for those of you who are not familiar with our firm, just give you a little background on Badmus Associates. As I said, I'm Ann Badmus, founder of Badmus Associates, and over the years, we have helped thousands of clients gain legal immigration status in the United States. We have been fortunate to receive honors such as Best Lawyers in Dallas for Immigration, as well as selected to the Best Lawyers list for Best Lawyers list, as well as the Best Law Firms list for immigration by Best Lawyers magazine. So we are lawyers, so as lawyers, we always need to give you legal notice as we present this presentation that the presentation is for informational purposes. Please do not take it as legal advice for your own situation, because there is no one size fits all to any legal matter, especially not in immigration. So you really would need to reach out to us or another professional, qualified professional who can really understand your situation and explain or determine what your options are for any of these visas or any other immigration matter. So again, this information provided today is a very general information to give you an idea of the possibilities that might apply to your situation, but for you to know for certain whether it is a good option for you, you should reach out to an immigration professional. And we'll have our details towards the end where you can reach out to us. And you should also have that, since you are on the webinar, you probably have our details, so feel free to reach out to us as well. So before going on to the next, before talking more in depth about those options for those who are interested in doing business in the United States, whether you're already doing business or interested in starting up business, there's some basic information, basic immigration facts that you should know. First of all, visa or legal status, if you are, is not required if all you want to do as an owner of a business is to be a passive owner. So what a passive owner is someone who just invests money, but they are not involved in the daily operations, in the marketing, or anything that's related to that business as far as operating that business. Instead, you simply give money or invest money and hope to get a good return on your money. So things like buying stock in a business or owning real estate, where you do not act, or you're not actively involved in the production of income from that real estate, or if you're just providing assistance to borrow money in order to invest in a business, those things are not, you are not required to have a legal visa status in the United States. So you can be someone who is not in the United States or even in the United States and do those things without needing to have any of these specific visas that we're going to talk about today. However, if you are going to live in the United States and or work in the United States, you do need to have legal status in order to do so and not be in violation of immigration rules. So the next thing to know is that self-employment. So self-employment is, or doing business, is considered employment in the United States. So oftentimes we get the question, someone is here on a visa, maybe even on a student visa, and they want to be involved in some kind of business where they actually have to produce some work on behalf of that business, but they are the owners of the business. Well, that is still considered work, whether by the U.S. government. So if you are planning to engage in any kind of work, whether it's for your own company or someone else's company, you do need work authorization from the USCIS, which is the agency that's responsible for issuing visas in the U.S. Next thing to know, just basic fact to know, is that the options for legal status, they're not many, but we will go over quite a few today, but not as many as we would like. But essentially, they're kind of divided up into two categories. So one is non-immigrant temporary visa, which again, like the name implies, it is meant for those who do not intend to, at least with that visa, permanently remain in the United States. They are coming here for a temporary purpose, whether it's to visit, to go to school, to engage in business in some respect, or to work. Could all be related to temporary status. Immigrant visa, or what we call the green card, is permanent status. So getting an immigrant visa or getting permanent residence, they're all the same thing, or getting the green card, all means the same thing, means that you now have the permanent ability to be in the United States, to work in the United States, and eventually, if eligible, become a U.S. citizen. So, as we mentioned, this webinar is about U.S. immigration options for startups, as well as those who are already in operations. Many of the things that we'll talk about today isn't necessarily restricted to a startup company. So a startup company being a company that is just in the first stages of operations. The basic business requirements for startup companies or any company in the U.S. As it relates to immigration is that typically many of these options that we will talk about will allow you to be 100% owner and qualify for that type of whatever type of visa that you might otherwise meet the requirements for. Usually you will need to, though, have a corporate structure or a company structure. You will need to set up a company that is considered separate from you as an individual. So in the US, we have various company structures, or people can operate businesses in different ways. Many people operate without a separate company structure. So they are what's called a sole practitioner, or even a partnership or sole proprietor. They have not set up a separate tax structure. They are just operating as themselves. And so that is one way to do business. However, if you are looking for immigration status in the US, that kind of business structure is not allowed. You have to set up a separate corporate structure that would be considered a separate entity from yourself as the owner in order to be able to apply for certain visas for operating a business. So the typical company structure that most people use is what's called a corporation or an LLC. Now, we don't have the time to go in depth into all the various reasons for using whether you want to use a corporation or LLC. I usually advise that this is very much a tax question, as well as a company, or as well as a corporate structure question. So usually advised to speak with an accountant, a CPA, or someone well-versed in tax structure in the United States that can help you also determine, aside from the immigration implications, how a particular structure will affect you as far as tax liabilities are concerned. But again, for immigration purposes, you do need to set up one form of corporation, one form of business structure as I've mentioned here. In some cases, some of the basic business requirements for a visa would be that you show some investment or funding that has been obtained in order to operate your business or to start your business. And then also some of these visas require that you have actually started operations or are nearly ready to start operations as part of the visa requirements. So what are the various requirements for startups or entrepreneurs? There's, as you can see, there's quite a few listed here, but they're all have very specific and some oftentimes many different requirements. So again, in order to know whether any of these options really fit you or fit what you can do, you would need to really meet with an attorney to discuss a lot of different information so they can determine whether this would apply to you. So we will go over each of these categories in the time that we have. And then again, of course, if you have questions, as I mentioned, please feel free to ask questions along the way. But towards the end of the presentation, we will respond to questions. So we'll leave some time for that. So we'll talk about different types of visas, these immigration options in the order that you see on here on this slide. So let's just go directly to the first one, which is the H-1B specialty occupation visa. So H-1B visas are pretty well known, and a lot of people know that their H-1B visa is available for those who are in what's called specialty occupations, meaning that their job requires a minimum of a bachelor's degree in order to qualify for the job. And of course, the individual person applying, if you're applying for an H-1B, then you must also hold that required degree. So that's key to even thinking of doing an H-1B. The job that you plan to do for your own company, if you're going to do this in the self-employed route, must be a job that fits within the specialty occupation requirement. Then, of course, this is an employer-sponsored type of visa. So the H-1B does require an employer-employee relationship. An employer sponsor is required. And that means that the company that sponsors you for an H-1B must treat you as an employee. And that means they must pay you as what's called a W-2 employee. So it's a typical employee structure in the U.S. They have to treat you as an employee. They cannot treat you as self-employed, or not self-employed, cannot treat you as an independent contractor where they are not responsible for your tax, withdrawing taxes or making sure that tax liabilities are taken care of. Also, that they must also follow tax laws as required for employers to make sure that they're paying the required tax responsibilities that relate to each employee. So as an H-1B employee, you can work with any H-1B, you must work with the H-1B employer that has sponsored you, but you can have many different, or what we call concurrent H-1Bs, which means you can have many different employers at the same time and work for different employers as long as each employer has been approved as an H-1B employer. And then finally, with this H-1B basic, and again, these are very, very basics. There's a lot more rules and requirements related to the H-1B visa, but I'm just covering the very minimum that we need to look at to determine whether or not you can use an H-1B visa for your business structure, for your business visa. So H-1B visas can be granted for up to 3 years at a time, with a maximum of 6 years for the individual employee to hold H-1B status. Unless they have a pending green card application, and in that case, they can extend H-1B status indefinitely until they actually receive the green card. So saying all that, how does that relate to self-employment or operating your startup business under the H-1B visa? So if you're a founder or an owner of a company in the U.S. and you want to look at H-1B as an option for you to hold legal status to work in your business, then it is possible, but there are certain requirements to be met. As I mentioned, you can be 100% owner, so that's definitely possible. We get a lot of questions from people that wonder if they could actually own any part of a company where they are an H-1B employee? And the answer is yes, it is very possible to even own 100% of your company, and that company, if structured as a corporation or an LLC, can sponsor your H-1B visa so that you can work in that company. However, you do need to be sure that the work that you're doing does qualify as a specialty occupation. So just as some examples, but this is by no means the full list of specialty occupations, but we've worked with many physicians, dentists, IT professionals, startups that use the H-1B visa as the way for them to operate their be in charge, operate their company, but also do the work that's necessary to run the company. And so if you meet that category of having being a specialty occupation, then it's very possible for you to qualify for an H-1B visa. However, the last thing to think about before, or one of the things to think about before going using an H-1B visa, is that H-1B, if you already have an H-1B visa, if you've already been counted in the cap, and you may want to now move from your employment and start to go work in your own company, which is what we've often helped people to do. They're already H-1B, they've already received an H-1B, and now they want to start up their own company and start working in that company. Then that's an easier route. But if you've never had an H-1B, so for example, if you are a student, foreign student, and you are wanting to start up your own company and go this route of H-1B, then you have to be mindful of the H-1B cap limits. So for any new H-1B individuals, in order to be sponsored by your own company or any company, you have to compete for the very limited number of H-1Bs that are available each year. And right now there's only 65,000 H-1Bs plus an additional 20,000 new H-1Bs for master's degree applicants. So we're only looking at about 85,000 H-1Bs every year that are available for new applicants. And usually there's almost 300,000 or more. This year there was over 400,000 people trying to get one of those 85,000 visas. So as you can see, it's pretty competitive. There may be some ways around this, but you would definitely need to meet with an attorney to determine if it's possible for you not to be required to go under this limitation. So finally, I wanted to let you know there is a proposed change in the rules for H-1B self-employment, which is what I've been talking about. So self-employment, where you start up your own company and your company is sponsoring you for the H-1B. Now, while we have been able to help people start up their companies and use H-1B as their way of working for their companies for quite a bit of time, for over 10 years or more, the government is now implementing some rules, which actually in some ways are better than the current rules. But this year we expect that the rules will change for those who are owners. Again, people who are applying for H-1B as sponsored by their own companies. There are some changes that you should be aware of, or that will probably happen later on this year. So, for example, if an H-1B employee owns more than half of the company that's sponsoring with them, then yes, it's definitely clear, which we've always done anyway, that they can apply for an H-1B visa. However, you need to spend most of your time, over 50%, doing that specialty occupation work. So for example, if you're a physician, if you are an engineer, if you are an IT professional, whatever your profession is, you need to be spending most of your time doing that kind of work for your company. So it's not a pure CEO position where you're just managing people and not doing that kind of special work that's needed in order to generate revenues for the company. So you have to balance that business management with the specialized work. And the other change, which is really different, is that while normally individuals will get 3 years on an H-1B whenever an employer applies for them, if you are going the self-employed route, then the government is going to limit the first time that you get an H-1B as self-employed to having the first 2 times that you were applying. So basically, when you first apply for this type of self-employed visa, you're going to get 18 months, so about a year and a half to have H-1B status. Then you can also renew for another year and a half. After that, if you are still interested in continuing, then you can get 3-year renewals as long as you meet all the other requirements. So that's a change that we're expecting. But currently, if you're wanting to apply now before this new rule comes into effect, then there is no limit on the time frame as far as how many years you can have an H-1B as a self-employed individual. You can have, well, there is a limit, but the limit is the usual limit of three years. Okay. So the next category that I want to discuss is the O1/EB1 extraordinary ability category. So we have, I framed it this way as 2 different types. There's 2 different types of visas. We have the O1, which is the temporary non-immigrant visa, which can be extended indefinitely. There's no limit on how long you can have an O1 visa. However, it is a temporary visa, so it does not lead to permanent residence. It does not lead to citizenship. And it does require company sponsorship. So you do have to have a company structure that will be your employer of record if you are applying for O1. However, O1s someone being self-employed with an O1 is very, very common. So as long as you've set up that company structure, your 100% ownership of the company that is sponsoring you is perfectly acceptable. Then you have the EB1A, which is the immigrant visa. As I mentioned, this is permanent residence or the green card. It does lead to citizenship, and it does not require an actual company sponsor. This is something that you would apply individually. However, you can apply individually as anticipating that you will be operating a business in the United States. So that's why I bring up the EB1A option as an option for entrepreneurs, because if your goal is to come to the US and operate a business, then this could be an option for you to get permanent status to do that, as long as you meet the other qualifications for the EB1A option. So EB1A and O1 have very similar criteria. We don't have the time to go through a lot of detail. I do have other webinars and videos on YouTube discussing this criteria in more detail, and we will have future webinars to discuss this in more detail. However, I do want to mention that it's very important that if you are considering this option, that you really need to know the details of the different criteria that's required. But essentially, if you are going under this route, you must prove that you are considered to be at the top of your field. So for example, if you are, sorry, I just skipped over here. Yes, so if you are at the top of your field in any country, so for example, if you are from France, as an example, and you would need to show that you are considered to be one of the best in your field in France. So when we talk about fields, we're talking about any occupation. You can be a researcher, a physician, musician, artist, entrepreneur, any occupation, legitimate occupation that you can think of. If you can show that you're coming to the United States to engage in that occupation, and you have been well recognized in your country or even internationally recognized as one of the top in your field, one of the top entrepreneurs, one of the top musicians, physicians, any of those, then you could qualify for the EB1 green card, and you don't need to have an actual employer sponsorship. You can just show that you intend to come to the United States to engage in your occupation. And of course, if you're approved, you do come to the US in order to do that, in order to engage into your occupation. Okay, and so the next one that I will discuss is the EB2 National Interest Waiver. So this is also a green card option. So this leads to permanent residence if you qualify. And the EB2 National Interest Waiver is one of the few that allow an individual to apply for this green card without having a specific job or an employer to sponsor them. However, you must show that you intend to be employed in the United States in whatever occupation that you normally do. So you must be an advanced degree professional, and I'll talk a little bit more about that, or prove exceptional ability in any field. And most importantly, you must show that if you are either in the United States and want to continue to stay here as a permanent resident, or if you want to come to the United States and be engaged in your occupation, that your work in the US will have national benefit. It will have national benefit. So the national benefit varies. There can be so many different benefits. For example, if you're in oil and gas, that could be a benefit where your work will benefit the oil and gas industry and will improve energy resources. Or another example would be research. That's the typical one if you're involved in medical research, and that will also help benefit the U.S. in healthcare. If you are coming in finance, that could also be another one. If you are, for example, developing a fintech software, and that is going to, of course, benefit the U.S. in some way. Again, these are just examples. No one size fits all. These examples are examples of those, some who have been successful in this regard, but every individual case is different. So these are, again, just examples for you to see that, or imagine the different ways that you could possibly qualify for the national interest waiver. So as I mentioned, the national interest waiver does require a minimum of either having an advanced degree. So that would be an advanced degree. So you would need to have either a master's degree or higher, such as a PhD, or if you have a bachelor's degree and you have more than 5 years or more experience in your field of expertise that you're coming to work in, then that would also qualify as an advanced degree. Now, if you're someone who does not have an advanced degree, or maybe even an advanced degree, maybe you have a bachelor's degree, but not the other years of experience, or maybe you don't have any degree at all because it's not typical for your, there's no need for a degree in your field of expertise, then you can still qualify if you show that you're a person with exceptional ability in your field. So for example, in business, if you are a business person and you don't necessarily have a degree related to business, but you've been operating business for 10 years or more, you are involved in some membership and professional associations, you might have some type of degree. It may not necessarily, it could be a lower degree than a bachelor's degree, but also you have some significant contributions that you've made to your field of expertise. So as you can see, there's some ways for those who don't meet that advanced degree requirement to potentially be eligible for EB-2 national interest waiver if they can show exceptional ability. As you can see, there's a lot of different criteria, and it's a case-by-case basis. So it's important to really look into your career and see if any of these criteria could be met by the things that you've done or accomplished in the past. So finally, I think what's really critical, we get a lot of questions about EB-2. It does seem to be a very popular option that more and more people are becoming aware of and thinking that they may qualify for the EB-2. But it's important that, again, it's not just the master's degree, it's not just the exceptional ability that you have. You also really have to show exactly what you will do in the United States that is going to have substantial merit and national importance to the United States. So that's what's called the proposed endeavor. What will you do that will benefit the U.S. in technology, maybe healthcare or education, in business competitiveness, entrepreneurship, job creation? You have to show how that will be done. And you also have to be very specific. So it cannot be just that this is what I'd like to do and I would plan, I think this will benefit the United States. You have to provide data. You have to provide detailed information. You have to provide recommendation letters, many things that have to be supplied in order for the government to believe or agree with you that your work will have substantial merit and national importance. If they agree with that, then you also have to show that you are well positioned to advance that proposed endeavor. So what they mean by that is that you need to show that you have the credentials, the qualifications, you have a record of success, you have support from others, maybe especially in business, if you have financial support, if you have funding, if you have other government interest in your work, all those things. If you can show that, then that goes towards showing that you are well positioned to advance the proposed endeavor. And then finally, the third criteria that the government looks at is, how will it be better for you to be in the United States? How is it more important for you to be here in the US in order to advance the proposed endeavor, as opposed to you just going to go get an employer who will go through what's called the labor certification process and just prove that there aren't enough US workers to do your position. That is more of a legal argument to be made, and it's certainly doable, but that is one of the criteria that is required in order to prove that you do meet the national interest waiver criteria. Okay, and again, I see questions coming up, and be assured that we will be answering those questions. If you are putting them in the chat, please be sure to move them over into the Q&A section so that we can keep track of it. Next, I want to talk about the L1A multinational manager executive visa. So this is a temporary visa. Temporary work visa. There's no limit on the numbers of L1A visas available, but this is for those high-level executives or owners of companies, multinational companies. And when I mean multinational, I don't necessarily mean like the huge multinational companies that we know of. It can be that you have a business that you are operating outside the US, and you will continue to operate that business, but you want to start a subsidiary or a branch or another business, affiliated business in the United States. And so if you want to start up that business in the US, you would basically show a couple of things. First, you need to show that the foreign company that you have and the US company have the qualifying relationship. So for example, you as the individual owner own 100% of the foreign company, and you're also going to own 100% of the US company. Now that's an example. There could be other qualifying relationships, but that's one of the easiest ways to qualify, is to show that you own 100% of both companies. You must also show that you have been employed with your foreign business for at least 1 year within the past 3 years before you apply for the L1 visa. So that requires you providing a lot of payroll or tax information or other evidence to prove that you have been working with that business for at least 1 year. And then, of course, you also must continue to operate. If you do receive the L1 visa, you can't just close up your foreign business. You have to keep that operational while you are also operating the US business. So that makes it truly multinational. You have to continue running both those businesses during the entire time that you have an L1 visa. If you close up the foreign business, then your L1 visa becomes invalid. So it's very important to keep that going. And then we also have the potential for now, once you have operations for at least 1 year in the United States, you have the potential for getting, for applying for and potentially receiving the EB1C green card. That is through what's called the multinational executive or manager, the EB1C. So the EB1C is very similar to the L1 in terms of criteria. It basically requires that there's, again, a foreign company and a US company with a qualifying relationship. It also requires that the people who are applying for an EB1C green card are only top level managers or executives. Of course, the owners who are operating the companies on an executive level would qualify. So you as an individual owner, if you are also an executive in the company, then you could qualify as a top level manager or executive for this EB1C. But you must also prove again that you have worked with your foreign company for at least 1 year in the 3 years before you came into the United States. And of course, you must show that the US company is fully operational. You must have at least 1 year of tax return from the US company, and ideally show that there's been some profitability to that company, and the need for you to be here on a more permanent basis. So next we'll go quickly to the Treaty Investor E2 visa program. So the E2 visa program is also a temporary visa, and it is a very popular program for those who can who are at least a citizen of a treaty country. So there's about 50 countries that do qualify for the E2 visa. I have the website listed here to see which countries do qualify. So if you go to that list, you will see all the countries that do. Most of them are typically in Europe, some in South America, very few countries in Africa, some in Southeast Asia. Australia also has them as well. So if you are Canada, of course, also qualifies. So if you have citizenship, and even if that is not your country of birth, but you have citizenship in any of those countries that are on that list, and you could qualify for the E2 visa program. So what is the E2 visa program? It is an investor visa program, as the name implies. So you must show that you have made an investment that is substantial in a real operating enterprise. And when we say real operating enterprise, what we mean is that it can be a startup or startup business that you're starting yourself from setting up the corporation, finding the location, determining the business plan, all those things to show that it's a real potentially operating enterprise. But it also can be a purchase. So you can buy an existing business and still qualify for the E2. And in fact, that's usually an easier route, is to buy an existing business, but startup businesses certainly can qualify. And it can be any type of business. There's no specific type of business that qualifies. It can be retail, it can be commercial, it can be consumer-based business. Sometimes it can even be an online business if it's properly structured. There can be various ways that you can qualify through the E2 visa. But what's also key is that you, as the owner or the investor into this E2, into the business, you must own at least 50%, and you must be coming to the United States to work in the business itself. So you do not receive an E2 visa to invest and then go work in other places or do other things. The E2 visa is for the individual to be able to come to the US and develop and work in that business to make it successful. A related e-visa program is the E1 visa program. Now, this is less used because it's typically for those businesses who are already operating outside the US, and maybe they have quite a bit of trade. So if you have more than 50% of your business being consumed or purchased or done in the United States, so for example, if you export goods to the United States or even export services, like you have engineering services, technology services, more than 50% of your business is done with companies in the United States or selling products in the United States, and you also are a member or a citizen of one of the treaty countries that's on that list, then you could potentially receive or get an E1 visa in order to continue to operate in the United States. Let's say if you wanted to start a branch or start an office in the United States so that you can get closer to your customers here, then that could be an option as well. So the last two that we'll discuss before we go on to questions is the EB-5 Immigrant Investor Program. So many people have heard of the EB-5 program. It's been around since 1990. It has changed in some ways in the past few years. What I'm talking about on this slide would be what's called the direct investment EB-5 programs. There's two ways typically that people will apply for the EB-5 and get an immigrant visa. Again, the EB-5 program is an immigrant visa program, which means it's for permanent residence. It is not a temporary visa. So therefore, it does take quite a bit of time to apply for and be approved for the EB-5 Immigrant Investor Program. So as I mentioned, there are two ways that you can apply for this program. One would be through what's called the regional center path, where you invest your money not indirect, but you invest your money with an approved, pre-approved fund, almost like investing in a stock or almost like investing in a mutual fund or something like that, where you're not really going to be actively involved in the operations of that regional center or of that fund. You're going to put your money there and hope that it will grow or not be lost. But that fund itself will be responsible for meeting the qualifications of the EB-5 program. So there's tons of those types of funds out there. There's probably over 500. There used to be almost 1,000. It's been whittled down to a lot less than that. But if you go that route, there's very little management required on your part. Whereas what I have on this slide is the direct investment. So if you want to have more control of your money and you want to be the one that's operating the business, and this is another route for the EB-5 program, is that you will either invest in an existing business or start up a new business, but your investment must be at least $1,050,000, or it could be $800,000 if your business will be operated in what's called targeted areas, either rural areas of the United States or areas that the government has determined have low or high unemployment rates. So sometimes in inner city locations, places where there's not as much employment as at others. So if you're locating your business in those types of areas, and it's an $800,000 investment. We often get the question, so when do I have to invest that? You actually have to invest that. You have to show that your money has started to be used, or at least put into an account where it will be used for the business before you even apply. So it's not, I apply and then they approve me and then I start investing. No, you have to start the investment before you apply. And you must be able to create at least 10 full-time jobs for U.S. workers as part of your plan over a 2-year period. This EB-5 direct investment requires that you are involved in the operations of the business, whether it's CEO or whatever management role that you have. And what I think is probably, to me, not the greatest thing about the immigrant investor program is that it takes an incredibly long time to get a decision on from the USCIS whether or not they have approved you. Right now, application processing times is almost 5 years, which means that you've invested your money and it's sitting there for 5 years before you know whether or not you're even going to be approved. However, it is an option for those who feel that there's no better option for them, so that you can, and if you're able to invest that kind of money and not need it for the 5-year period or more, then it is an option. And if you're in the United States in a legal status, then you could be eligible for a concurrent filing of adjustment of status, which means that you can stay in the United States while you're waiting for your EB-5 application to be approved. And then finally, I will talk very briefly about the International Entrepreneur Parole Rule, or IER for short. This is just sort of the unicorn. It's a different animal than the other visas and immigrant visa and temporary visa. This is actually not a visa. It is a permission. So parole under the government rule simply means permission. It is a permission for an entrepreneur who has at least 10% ownership of a company that has been developed in the past, has been started within the past 5 years. If you want to be in the United States to take an active role in the operations of the company to help continue developing the company, then this might be an option for you if you can show that you have either received substantial investment, at least $250,000 or more from U.S. Investors, or if you've received government grants or awards and there's specific amounts for that, or you show other evidence that your company has the capability to really grow, then it's possible that you could get an IER. The IER can be approved for up to 3 entrepreneurs per startup company, and usually, if you're approved, you get 2.5 years to have the parole, and then an additional 2.5 years. So the maximum currently is about 5 years that you can have this parole. It does not lead to citizenship. It does not lead to permanent residence. It does not even lead to a temporary visa. It is just a permission to allow those entrepreneurs who want to be involved in their U.S. startups to stay in the United States. Okay, so that ends the list. There are some other options. I think in some of the questions, people did have questions, so I'll definitely address that. So now that we sort of ended our presentation with in that respect, let me go on to the questions. And I think we have a good amount of time for that. Okay, so well, we have 3 votes for the question of what is the minimum investment required for a status company and what type of industry would you recommend? So I'm not sure what the status company question is. Sorry, it just needs a little more clarification. But if I'm correct in what you're asking is maybe an E2 visa would be a visa that you might have interest in if you qualify. That visa does not have a minimum number investment. It is really related to the startup cost. If the startup cost for your type of company or your type of business is $100,000, then you need to invest $100,000. If it's $50,000 to start up your company or to buy a business, then you must need $50,000. Now, the larger the investment amount, or the larger the startup cost, the less you have to invest in terms of percentage. So for example, anything typically under that startup cost is 100,000 or less, usually the government expects you to invest 100% of that startup cost. If you have a startup cost of $1 million, then it could be 25%, which still is about what, $250,000 they expect you to invest. So it's sort of a sliding scale. So it really depends on the type of business. And then the question of what type of industry would you recommend? There's really no recommendation on that. It's whatever fits your background that you feel you can be successful in, that you feel can be worthwhile in putting your money into. There is no particular industry that the government favors in terms of E2 visa. And in fact, for any of these types of visa options, there's no specific industry that's being favored at all. I will say that with respect to minimum investment, the only visas that actually have sort of an investment requirement would be the E2 visa, of course, the EB5 visa. Sometimes with the L visa, they do require some proof that there is sufficient funds to start up the company as well. But it's a case-by-case basis. So we really need to talk more in depth about your specific requirements to know whether that's going to potentially work for you. Okay. Next question is someone asked about what about the H-4 EAD? So the H-4 EAD is an employment authorization. If someone has an H-4 EAD, it is a blanket employment authorization. You can be employed in any capacity that you like. It can be self-employed. It can be you can be employed by anyone else. There's no restriction. So yes, if you have an H-4 EAD, then that is certainly a good option in order to run your own business. Another question. After EB2 NIW approved, if the I-140 date is not current, then do you still need an H-4 or other work visa so you can work in your own business? I mean, I'm sorry, not H-4, H-1B or other work visa. Yes. So yes, the answer is yes to that. So the I-140 approval is the approval that says you are eventually qualified. You are qualified to eventually receive permanent residence or your green card based on the EB2 NIW or any other category that you have been approved. That does not give you legal status to be in the United States. It does not give you legal work authorization. So if you are in the United States and you want to remain here legally so that you can eventually adjust status to permanent residence, then you will need to have some other visa to remain in the United States. And in particular, if you want to work, you would need a work visa, either an H-1B or any other work visa that might be applicable to you or that you could obtain. Okay, next question. Can buying land and construction of a building for a business in a rural area qualify for EB5 criteria? It's keep in mind that the EB5 not only has an investment minimum, it also has an employment minimum. The expectation is that your business will create 10 full-time jobs for people other than you, outside of your family. So it is land and construction in itself is probably not going to be enough. You would need to show how you're going to create 10 permanent full-time jobs. Now, what I mean by permanent, meaning that, you know, the business is going to need at least 10 employees to continue operations. If you're buying land and constructing a building and then the building's done, you know, you would have to show how you're going to continue to employ 10 employees. The only time that land and construction of a building alone can qualify for EB-5 is if you are applying based on one of those regional centers, where the regional center project is to build a building, and during the course of that building, of course, they will be creating 10 indirect jobs. So what indirect jobs mean, like construction workers and other contractors that will be needed in order to build that building. But that is only in that case. And so that means that you would not be involved in that particular project other than to provide the money to that regional center and hope that, you know, it works out as far as the investment is concerned. Okay, next question. The question is, what is the price to get an EB-2 visa? So I would suggest, depends, well, EB-2 visa, if you mean NIW, there's different types of EB-2. There's an NIW, and then there's also an EB-2 related to the PERM process. I would suggest to reach out to me privately to get that. I will tell you the government fees that are charged is $1,015 for the government fees for regular processing. If you want the fast track 45-day processing for the EB-2 NIW, then it is an additional $2,805. And the last question I have here, if there are any more questions, please feel free to add them. We still have a little bit of time. So if you have more questions, go ahead and put them into the Q&A section. The question is, can I start a business on a R1 visa? And the short answer to that is no. The R1 visa is meant for religious workers to work in a church or a religious organization, and only for that religious organization. If you work outside of that or do business outside of that, then that is considered unauthorized employment in itself. So basically you cannot do that just based on your R1 visa. If you're looking to start your own business, then you would have to look at other options besides the R1 visa. Another question is, any problem if the U.S. LLC is not owned directly by me? Instead, it is owned by an offshore company, and the offshore company is owned by me. As far as applying for E2 or EB-2 visa. Okay, so for the E2 visa, you do need to, well, yes, that could work if you own the offshore company and the offshore company owns the U.S. company that you start up or that is started up in the United States. And of course, you make the investment needed, or you show that the investment has been made, the necessary investment in the U.S. business has been made, then it's very possible to do that. You can actually have another foreign company own the U.S. company, as long as you, as the foreign company owner, has the qualifying, owns at least 50% or more of that foreign company, and you have the qualifying citizenship. You know, you're a citizen of one of the countries that does qualify for the E2 visa. As far as the EB-2 visa is concerned, the only EB-2 visa that you probably are referring to would be the national interest waiver. And in that case, it is possible to have it structured that way as well. Usually, if you're doing an EB-2 visa, national interest visa, you will need to show either that you have operations already, or if that's not feasible, you have to have a really strong business plan, as well as for the E2 visa, a strong business plan to show how you will be able to operate the business in the United States. Okay, see that we have a few more minutes, so I'll answer a few more questions. What is the maximum time frame for the E2 visa? So the E2 visa, usually if you get the visa at the U.S. Embassy in your country, they usually issue a 5-year visa. That 5-year visa allows you to come back and forth into the United States. And every time you come into the United States, you will receive a 2-year stay. Now, your stay is determined by the I-94 document that's generated electronically when you come into the United States. So if you check that I-94 document whenever you come in, it should give you a 2-year period to stay in the United States without having to leave. But as far as maximum time, there is no maximum time for E2 visa. You can have an E2 visa indefinitely, meaning that you can keep renewing the E2 visa every 5 years forever. There is no limit on how long you can have an E2 visa. As long as you are operating your E2 business, you can continue to be approved for E2 visa. Next question is, where can I find information about EB-5 approved investments for indirect investments? Okay, so I will, I was trying to see, I can potentially put that into, let me see if I can put that into the chat. I think I can put that into the chat and give you the website link to that. So let me do that real quick. But there's a lot of the information on the USCIS website that will show there. Okay, here we go. It's called the EB-5 Immigrant Investor Regional Centers. So the list of them and a lot of information about those centers can be found there. So let me post it here. Here is the website into the chat, and feel free to click on that link there. Okay, let me see if there's any more questions. It looks like I've answered all the questions. I see no further questions. So as we conclude, I want to thank you all for attending the webinar today. Please remember again that the information provided is general in nature and is not relied upon for specific situations. So please reach out to us for your specific situation to get legal advice, whether or not it's a good idea to proceed with your immigration plans. If you've liked the seminar, we do appreciate a Google review. So feel free to reach out and go Google us at Badmus Associates and leave a review or use this link. And you'll also receive a recording of this webinar, which will also have other information for you as well. So thank you again for being with us today. Please note that there's handouts as well. So if you saw the handouts, go ahead and grab a handout. If you need a handout, please contact us as well. Thank you very much and have a wonderful day.